Ooh, that was a good one. Okay, I believe we are live. It is. I'm not even going to check my phone to see what date it is. It's a Sunday. This much I know for certain. Let me go to the chat and see people try to troll me with F saying my audio is no good. Oh, yeah, there I go with my first hands through the hair. Read into it what you will. How's everybody doing? This has been an eventful week, notwithstanding the lockdown curfew imposed in Quebec. I've been doing my every other day sort of update from the street, which have been kind of fun. Audio's great, sounds good. F broken soapbox. Oh yeah, here we go. Here's one comedian. There's always comedians in the house, people. So let's see. Hold on. Every effort's for Paul. All right. There's going to be a running gag, by the way, for anyone who did not tune in to the Dershowitz-Barnes debate, which was actually quite civil because I think, if anybody doesn't know, there was the live stream debating forced vaccinations. Alan Dershowitz had expressed his position in the past, had taken some heat for it, did a debate with Robert F. Kennedy Jr., which I hope everybody goes to watch because that was an interesting discussion as well. And then Robert Barnes and Dershowitz had it out, but they weren't really disagreeing with each other substantively. I think ultimately, the position that Alan Dershowitz puts forward, that if it's safe, if it's effective, if it prevents transmission, and if it's highly transmissible and highly fatal, then, and I think by and large, most people would agree that if these hypotheticals all come together, then. And so that's why I think Robert and Alan ultimately agreed to some extent, but they disagreed on some issues. But the joke being, Robert shall hitherto be known as Paul, because at some point Alan got confused and started calling him Paul, and I said, I either ignore this or I stare the elephant in the eyes, because it's not something you could ignore. But so it's become something of a meme now. Robert shall hitherto be known as Paul Barnes. Okay, and now I see Cleopatra is in the house with the super chat, and the first that I see, but I see two more. Thank you very much, Cleopatra. Hi, Viva. Hi, Barnes. Trump has not committed crimes, yet they impeached. Does this mean they will prosecute him for his non-crimes after leaving office, but not Hillary? Not hypocrisy on the left amazes me. Now, Cleopatra, thank you for the super chat. We will get to that. And from my understanding, as we discussed with Dershowitz in the last stream, it's not clear they can try to impeach him once he's left office, but that's seems to be an open debate for some and a shut debate for others. But we will get there, Cleopatra, which is the perfect segue into me saying, I thank you all for the super chats, and fair warning, so all of you know, YouTube takes 30% of the super chats. If you support us on other platforms like Locals takes 10%. Stripe, the payment plan, takes like 2.9%. If you support us on Patreon, I forget what it is. On Patreon, PayPal is a minimal transaction fee. Subscribestar, there's every platform takes a cut, but YouTube takes a 30% cut. So first off, thank you very much for all the super chats and the support. If we don't get to them, don't be miffed. And if you're going to be miffed, if we don't get to them, don't give them, because I don't like people feeling bad. That's the first caveat of the evening. It is also not a right of entry into the conversation. I try to get to them. I try to bring them up in a manner that's not interrupting of the discussion or distracting. But I don't get to all of them, and it's a wonderful problem to have, but it is a problem. So if you're going to be upset if I don't get to it, don't. Do the super chat, please. But thank you all for the support. Now, what else? No legal advice. This is educational, or as we like to say in Homer Simpson land, educational. We're going to discuss a bunch of good legal issues this week. It's been a big week. Once I'm done ranting about my Quebec lockdown, we're going to get into the juicy stories. You've got on the week this week, Rick Snyder, former Michigan governor, charged. We've got Parler versus Amazon. And there's been back and forth and back in that because they're asking for a temporary restraining order. There's been a lawsuit, a defense, and a response to that on the TRO. Rumble versus Google, an antitrust claim. Very fascinating. Let me just go back to my notes here. Yes, Trump impeachment. We may get to the forced vaccine. And that should be it for the evening. And then the other side of this is I don't know. So that's what we're going to talk about tonight. It's going to be great. And while Robert comes in, let me rant about Quebec. This is non-alcoholic. This is what was left over, the kids' juice, a little lemon water, and ice. Okay. You know what? Before we do that, Let me just take up some super chats because we have time now. Okay, we got Mike Dolan says, I am concerned with over 26,000 some armed soldiers plus law enforcement militarizing capital across the country. Is the Constitution still viable? That is a question that's, look, at the world is moving. Paul Barnes, mall lawyer. All right, we got that. We got Brendan Saltvick says, no questions for me. I'm grateful for you and Barnes educating us on the issues. Brendan, our pleasure, and thank you for tuning in. What else we got? Let's see this. I guess. What do we got? That would be the first movie reference, if only by quote, and it's from Heat, when Al Pacino shows up to one of the crime scenes and he goes, what do we got? Shut up and take my money. Thank you, Bruce Wayne 23. Is that the Bruce Wayne? Bat Dad? And we got Paul Damick says, hi there. Hi, is there a public list with all the voter fraud cases? My Google skills are failing me now. Great show. Now the Associated Press has just throttled me in the back and said that I must remind everyone. I'm joking. Okay, let's see what else we got here. We got, do you have a Bit wallet for donations? No, but I'm thinking of opening one because Bitcoin might be the wave of the future, or it might be like every other stock I buy, bankrupt in 2 years. The compound of the paper is urea. Dirty. Okay, now let me bring this one up. Someone just said Paul Barnes is going to get old fast. Hold on. Second movie reference after Paul Blart. Okay, let's see here. Let me just talk about what's going on in Quebec for those of you who don't know. When I first started doing these vlogs, I never appreciated the difference in freedom of speech and the respect for freedom of speech in the States versus Canada. And now I fully appreciate it is a primordial difference, almost a religious respect for First Amendment rights in the States that I never appreciated the radical difference between the States and Canada. Now, as far as it goes to constitutional rights, COVID has been the issue now that has, caused a lot of governments to do some interesting things in response to the virus. Quebec recently announced that we have so many new cases and the hospital is on the brink of being overwhelmed. Incidentally, this was the exact justification for the 2-week lockdown to flatten the curve a year ago. Back into flu season, and apparently by Quebec standards, the flu season, even in the ordinary run of the flu season, stresses the hospital, borderline overwhelms it. So our government, over Christmas, as if anyone thought it was only going to be 2 weeks, shut down non-essential businesses. Essential businesses could remain open, but they could only sell non-essential items, which led to absurdities. What's the word I'm looking for? Milgrimish absurdities of half aisles being saran wrapped off with little notices saying, by virtue of the government recommendation or decree, whatever it is, we can't sell these non-essential items. It was one of them. I did videos on this. It was hair dye, brushes, socks. Okay. That got extended now. Non-essential businesses are shut down for another month, I think, because, to stem the spread. Because the hospital system was apparently on the verge of being overloaded, they issued a lockdown and a curfew. So you can't leave your house for a month. And anyone taking bets as whether or not this is going to be extended, my bet is yes, because when something that has no actual correlation in science to the desired effect, and it's not going to generate the desired effect, what's the government going to do? Renew it. And I'm not stating my own opinion. Dr. Aruda, who is our provincial health director, admitted there's no concrete scientific evidence of the effectiveness of curfews on stopping a spread, because people can go out and about during the day, but they can't go out at night, which might incidentally lead to the paradoxical outcome that people are actually going to get stuck in places that they might have otherwise left, but for the fact that they had to be home by 8. Okay, so I've been venting a little bit, going out on the streets and just sharing the news stories that relate to the curfew and the lockdown as things happen. Some funny stories for anybody who wants to live the Kafkaesque absurdity of Quebec now. The police fined a homeless person for not respecting curfew. Apparently it was an exceptional circumstance and, whatever. That's one absurdity. Another one is that a woman in Quebec, not in Quebec, in Sherbrooke, which is a city outside of Montreal, but in Quebec, was walking her husband on a leash, I guess as protest, but, maybe to test the limits. They were both issued $1,500 fines. So that won't work as a defense. People had asked me if you can walk other animals, and I wasn't certain. I mean, in the video, I said I thought, sure, if they need nighttime activity or whatever. Before I published that video, I looked it up, and no, cats. You cannot walk a cat on a leash at night. That is not covered by the government exception of dogs at night. This is the world we live in. Okay. Let's see what we got here. Any update about Patreon lawsuit? Also, might not be in the wheelhouse, but anything about the 3M earplug suit? Nothing about the 3M. And as far as I know, Omega, I don't know that they've had the hearing. If there's going to be a hearing, it might just be the written arguments, and the judge is going to issue the judgment. But I haven't heard any news on the Parler versus Amazon lawsuit. But while we're waiting for Robert, maybe I'll describe it briefly, just not to keep everybody waiting for too long. Here, actually, let me just make sure Robert has the link. You've got the link? ? Smiley face. Now Google knows that I emoji smiley faces. Okay, here's the evidence. Okay, so this is a link that we have up on our locals page if anybody wants to see it. And incidentally, locals, vivabarneslaw.locals.com. Imagine thinking concentrating people in a time window helps social distancing. It is a punitive measure when you have nothing else. And incidentally, that is what they basically announced during the, what is it called, when the government gives a public talk to announce something, the press conference. In no uncertain terms did they say, Dr. Arruda, the person in charge, said no direct, concrete scientific evidence. Whoever was giving the speech mentioned that this may not do anything, but it's going to serve as a stern reminder to the seriousness of the situation. Oh, that's what I forgot to tell you. Robert's here. I'm not going to do the Paul meme, but that's what I forgot to tell you. Our healthcare system is stressed and overloaded. And I was thinking, how many hospitalizations do we have? From COVID, 1,500 in a population of 8.5 million. That is stressing the hospital system to the point that a curfew is the only thing our responsible government thinks is going to respond to the crisis. They've had a year. And from what I understand, they've had a year every year because this happens every year, even in the absence of coronavirus. What did our government do? Didn't build up the hospitals, didn't put reserves, didn't train people, didn't create extra beds, whatever's needed to accommodate the influx that may result ordinarily and especially now. No, 1,500 hospitalizations from COVID results in 8.5 million people suffering a curfew. Okay, rant over, because I see him. He's dressed well. He's in his position. Okay, let's bring him in. Bring on the Barnes. Robert, how you doing?
Good.
I said I'm going to put an end to the Paul meme, but the jokes are going to continue. Okay, so we'll get into this first just before anybody gets started, because people always ask for the books. Let's start with the book recommendation for the week, and then we'll jump into a subject.
Sure. Big Mules and Branch Heads, about the great populist governor of Alabama, Big Jim Folsom, is his battles against the corporate establishment there in Alabama. Is sort of infamous. There he had a lot of successes, some failures along the way too, where he probably could have been more ruthless. I mean, what separated him from Huey Long was he tried to do things more diplomatically than Long did, though he lived longer than Long too. So, but one of the great populists of American political history.
Okay, good. So we got one book out there for everybody who's looking for the book, and we might get to one later. And we're certainly going to get to the movie references later. Let's start, I guess, with the one that I know the least about, but I was boning up before, Rick Snyder being formally charged. Rick Snyder is the former Michigan governor, if I'm not mistaken. He's a Republican, and we might touch on this in a bit as to who gets charged. So he is now being formally charged. I believe the two charges are dereliction of duty or something along those lines. And I don't know what the second charge is. I think at one point they were talking about manslaughter charges, and those are still on the table if he, apparently this is as good as it's going to get for Rick Snyder. So the Michigan Flint water crisis, everybody knows about. They diverted the water source from whatever the reservoir was to the Flint River. It was highly corrosive. Apparently, it was corroding the lead out of the pipes. lead poisoning in a lot of people, 3 times, 4 times the average lead levels in kids. 21 people died. It was a huge crisis. Everybody knew about it. We've all heard about it. They're charging Rick Snyder with 2 charges now and others. So it's not just limited to Rick Snyder. I mean, what do you make of it? And what do you think of the charges and the likelihood of any meaningful condemnation?
Well, it's basically criminal neglect, but to go after a governor for that for something like this, an environmental sort of disaster, is highly unusual. And there'll be those who question whether or not it's politically motivated, whether it's because he's a Republican and people involved in the prosecutorial process are associated or aligned with the Democrats. The Attorney General is currently a very partisan Democratic activist in Michigan. And so I think that will raise some questions. It's opening the door to criminalizing a lot of conduct that I think that's where people have some concerns to the degree that we're going to start criminalizing gubernatorial or well, in this case, gubernatorial, but in other cases, just governmental conduct in general. The flip side, it was an extraordinary disaster. There was extraordinary levels of neglect. It did lead to people dying. So, so I can see why they are pursuing some degree of justice and wanting people at the higher levels to take responsibility and be found accountable. So I think it'll depend on what the facts show ultimately as to whether or not was this a politically motivated prosecution to scapegoat one's opponents and adversaries, or is it an attempt to hold someone accountable and responsible where we have failed to do so in the past, but trying to start to do so where environmental disasters take place on the government's watch.
All right, and 2 things actually to preface that, because this is not an excuse and there's no but. It's a disaster, and there were some, say, outright or overtly, if not criminal elements, borderline corruption elements, as in when they did the tests on the water of the houses, they excluded certain reports that showed toxic levels of lead in the water so as to get adequate results to quell the population that there was no problem. Who made those changes? Who made those requests? Who knows? As far as it goes from a systemic failure, this is decades in the making of infrastructure collapse, bankrupt, a city being or a state being bankrupt, them having to find cheaper measures to provide services, and one of which was, while we try to redo the water, reroute it to Flint. So, there's more people being charged, but some people are asking, like, why is there no immunity for Snyder versus other politicians who have immunity in the execution of their duties?
Immunity is generally only civil. So you generally don't have immunity from a criminal prosecution, no matter who you are. It's just because the state controls it. That's really the de facto phenomenon that's taking place here. And so I think that that's why the distinction between the two.
Okay, that's a good answer, and it's a short answer. Now, the burden of proof, we have to see where this goes. There's going to be an investigation. Presumably there's been an investigation going on actually for, they say, upwards of 2 years. So presumably they have the information that is required in order to have issued these charges. Do they play the game and up them if there's no plea? Are they going to treat Snyder like an ordinary accused in the criminal system?
In all likelihood, yes, because he's not sitting governor; he's an ex-governor, and they appear to be escalating in what they plan on doing to him and with him. And I think one question will be whether or not other participants could have been culpable, but were not prosecuted because of their political associations. So I think that will be one of the things to watch moving forward, and then to see what the evidence actually shows at a trial. So the concern people have is weaponizing the criminal justice process to target one's political adversaries. But the flip side of that is that there probably should have been more of these in the past, where these kind of disasters have taken place on the government's watch, where the various high-ranking governmental actors are culpable and responsible.
All right, I'm going to read this. Alex Ayala says Trump had $160 million funded to Flint to solve the problem, estimated to cost $30 million to fix. The problem is Michigan is corrupt. They use the money for other jobs so they can ask for more, just like our roads.
Yeah, there's a lot of those. There's a lot of that goes around, unfortunately.
And not to get back to my rant about Quebec lockdowns, but while 1,500 new COVID admissions to the hospitals overwhelms the system, the government finds $13 million a month to spend on COVID awareness. Just not on beds, just $500,000 on an ad. Okay, so that's interesting. We'll see what happens with
where their priorities really are.
Well, it's always an interesting question as to who is in charge of the ad agency, which celebrities are getting hired, It's everybody. Government's good at lining its own pockets through taxpayer dollars with minimal added value for citizens. And it's only going to be a matter of time before actually criticizing the government is deemed to be insurrectionist behavior. Okay, so which lawsuit do you want to do first? Do you want to do Parler or you want to do Rumble?
Parler's good.
Okay, so Parler versus Amazon for the time being. Parler, as everyone knows, just the context, but I suspect you all know, pulled from Google, pulled from Apple app stores in the wake of the Capitol Hill riots. Same day, give or take, Amazon Web Services says we're no longer providing web hosting to you, and we're shutting you down, basically it was 24 hours notice at most, and pulls the plug, and literally overnight, Parler is wiped from the face of the internet. App doesn't work, and they don't have servers, so they don't have actual internet presence. Parler sues Amazon, seeking, among other things, say damages on the merits, but a temporary restraining order, like an emergency injunction, enjoining Amazon to reestablish, pending the lawsuit, their service so they can minimize their damages. And their argument is basically that this was antitrust violation, punitive to favor Twitter, the competitor of Parler. Amazon files a response, says they were in material breach repeatedly, blah, blah, blah. They were unable to do what we think they ought to have been required to do under the agreement to moderate their content. So we're justified. And Parler responds and says, no, you weren't justified. We were good in your books right up until the day before. Do you want to explain the essence of the antitrust lawsuits, the antitrust law, before we get into the actual lawsuit?
Well, I mean, I think that's probably the weaker component of their claim. But what they just simply pointed out was that Amazon has is financially profits from its relationship with Twitter, and that the more that Parler is unavailable to compete with Twitter, that Amazon will profit more from that than they do from their ongoing contractual relationship with Parler. And so it's a form of tying, though it's a little bit different in this context. The Rumble case is a little bit more cleaner case of tying, but basically that's it. It's just that there's so much economic overlap between these big tech oligarchs who all profit if they help one another at the expense of their separate competitors. But it's easier legally to get away with because the antitrust law has not always been interpreted to apply to that context.
Okay, and you're right. Actually, they had three aspects to the claim. I forgot to mention that: antitrust violation, breach of contract, and the third was, someone's going to have to remember the third while I go back to the second. So the antitrust claim is probably the harder of the three claims. The breach of contract, which is, and this is interesting. So Parler alleges that they're in breach of contract. The contract provides for a 30-day notice to cure. So if there's a material breach or a material default, Amazon has to notify Parler. Parler has 30 days to cure before Amazon can terminate. Amazon's argument is that we didn't terminate, we suspended, as if to say that we could suspend at will, but we can't terminate at will, which in my view basically means that they have no, if that's the argument, they can terminate at will, just call it a suspension. So what's your take on the breach of contract argument?
Parler has a very good argument on breach of contract and should win unless the court just sticks its head in the sand and covers for Amazon, because anybody that's familiar with this industry knows that for these kind of server relationships, your great concern is being turned off overnight. And so what you want protection against that occurring, to have enough time to get a replacement or substitute server company. And so that's why this is where that 30-day provision originated from, and opportunity to cure originated from. So Amazon's relationship with Parler, they promised Parler contractually, we will not terminate our relationship without first giving you an opportunity to cure, and we will give you 30 days to cure before we terminate. So it's basically like a notice provision and an opportunity to cure provision combined. Now, Amazon wanted to protect itself in case something truly illegal was happening, that they could temporarily suspend service until that illicit activity is immediately remedied. That's what they're playing games, and frankly, sometimes they were just flat out lying to the court about why those two contractual provisions exist. And the court will have to be intellectually dishonest to accept Amazon's defense, because Amazon pretending that, oh, no, we just suspended because we called it a suspension, is a ludicrous interpretation of its own contract. as well as the custom and practices of the industry in interpreting and enforcing that particular contractual provision. Under their interpretation, the termination clause meant nothing. It was utterly unenforceable, utterly useless, unless they themselves used the word. That's a preposterous application. So, and the key that Parler highlighted very effectively was that if this was a suspension, first of all, it would be based on something that they could cure quickly. And secondly, it would be something that they could cure, period. Neither was the case. Amazon made clear to Parler there was nothing they could do to cure, and that the problem they saw it was systemic. So what they were doing was terminating the contract. Amazon clearly breached the contract. And under Ninth Circuit law, some people were asking, well, couldn't you just recover in economic damages? And typically you don't get an injunction where you can recover in monetary damages, but not in the Ninth Circuit. The Ninth Circuit has said the destruction of your business is a separate, independent right to a temporary injunction. And clearly Parler has that in spades. So in reading all the briefs, I was curious, was Amazon going to have a defense as to how did it have some loophole or exemption? Instead, Amazon's defense, aside from, hey, judge, pretend this was a suspension, not a termination, in a way that's just a patently absurd interpretation of the contract and would make the judge a laughingstock if he said so, doesn't stop them, of course, but that would be where it would go. And its real predicate was political. It's, hey, we thought Parler did something really bad, and we are politically coming to the defense of the country and the nation. Nick Rekieta had a good explanation on his channel when he was doing an interview with Eric Hunley of the Unstructured podcast, which we recommend to people, which was that, and it reminded me of several books I'd read on this exact topic when he was talking about it in the context of Jack Dorsey and Twitter, that these guys have a version of a messianic complex, these big tech, your Bezos of the world. They're here to protect. They're more motivated by that often than they are by money, than they are even by power or control, that they are here to rescue and save the world. They had that's kind of what motivated, I think, Lin Wood. And so it's counter-rational behavior, and from an economic standpoint, but it's consistent with their true modus operandi. And that was basically their defense. Their defense really was, okay, judge, yeah, we breached the contract, but these people are bad people who promoted an insurrection. So just pretend the law isn't what the law is, and pretend the contract meant something different than it did, because here's our political defense. They don't have a legal defense. They have a political defense. And if the judge, now I'll give them credit, it's a Western District of Washington, a lot of iffy judges up in that district. It's in federal court, but they got a they got a Carter appointee. So if I were ranking appointees, and if the only thing I knew about a judge was their presidential appointment, which, by the way, I've found to be highly predictive of how a judge behaves, their personality, temperament, you name it. There's like a weird association between who appointed a judge and their nature. Not as much in Trump's case, in large part because of the Federalist Society's monopolization of that. But so for example, if I was ranking them, my favorite judge would probably still be a Trump appointee. My second favorite judge would be a Carter appointee. And then down from there, W appointees third, Clinton appointees fourth, Obama appointees last. They got a Carter appointee, is my understanding. So they're in the game. Those kind of judges tend to be commonsensical, tend to be fairness oriented, and they're going to think this punishment is excessive from a political perspective, and that legally Amazon doesn't have a defense. Amazon broke the rules and doesn't want to pay a consequence for it because they were doing it in the name of some higher calling.
But now, if you say it's a Carter appointee, how old is this judge?
Old.
Because all that I can do is think about my first, and I say not my only, but one of my first experiences talking in front of a judge about things like SEO, building traffic on Facebook, and how to value an online business. The judge, I say this without judgment, was what they call semi-retired. What do they call them? Surnuméraire in Quebec. So semi-retired.
In the States, they call them senior status.
So she was senior, but I'm not saying that to make fun of age. Semi-retired family law judge who, after 20 minutes, told all the parties that she understood search engine optimization, and then I knew that we were going to be in trouble. So, I mean, if you're getting a judge who, I am not playing ageism. Maybe my dad is more into tech than I am and knows more than I do, so some do and some don't. I might be nervous that a judge is not going to have any appreciation of how the internet works, and someone's going to say, well, get your own servers, and the judge is going to say, hey, look, why didn't you get your own servers type thing.
And then maybe that, but usually a judge like this, because Bertelsmann is similar, the federal judge presiding over a lot of the Covington cases, Carter appointee. They often tend to be more old school. So like Bertelsmann's, done some interesting rulings in some prior cases in the defamation context. He actually tried to gut Section 230. He thought it should read the way it was written and not the way the courts have construed it. So that you tend to get them like that. So because they're not neck deep in the high tech world, they sit there and say, "Well, do you have a contract? Okay, did you breach it? Yeah, okay. What's the remedy? Okay, Ninth Circuit. Here's what it is." So if he behaves like a typical Carter judge, Amazon should win. Now, no guarantee.
Do you mean Parler or Amazon?
I'm sorry, Parler should win. Okay. Parler should win. Amazon should lose. Parler should win.
Now, someone had asked if any of us are privy to the actual agreement. I have not seen the actual agreements. You've been reading the briefs. Have you seen the actual agreements?
My understanding is it was copied, but I thought it was sealed. So I thought it was attached as an exhibit, but I watched Nick Rekieta go through them all as well, and I think he was having some difficulty getting access to some of the underlying documents because some of them were sealed. Not all of them were. So but Amazon didn't dispute that. I was as soon as I saw Amazon's response, my curious was, are they going to say there's actually a contractual exception to this 30-day notice to cure? And they didn't even talk about it. And that's why I was like, okay. You guys got caught your hand in the cookie jar and you're just praying that politics is going to save you. And maybe it will, but it would be very embarrassing to have, when you have everybody in the industry has this contract for this reason. And the contract says exactly what it says. And when you're in front of the judge saying, no, we didn't terminate them, we just suspended them, but it's permanent and they can't fix it. Oh, come on.
And incidentally, I didn't quote the part from the lawsuit as to what Amazon said. We're suspending it if you need, and we'll help you migrate. We're going to save your data and we'll help you migrate to new servers, as if that's what you do during a suspension. Now, yeah. It's true. I presume, if there's a certain video, like I don't want to name any events, but if there's a video that's online, you could imagine that they could suspend for whatever in urgency, and then say take the video down, or it's an unfolding event.
That's exactly what that suspension rule is there for. It under their interpretation, the termination provision has no impact. So that's the problem. You can't have a contractual provision that is a critical, essential contractual provision that is completely inconsequential to the economic relationship. So there's no good argument that this is a suspension. And basically, they're asking the judge, "Hey, judge, lie to the world and pretend this was a suspension because we're on the right side of the politics."
And someone I brought up the comment before where someone said, if Amazon wins, it'll do more damage than good to them because every one of their customers is going to realize not their contract, but the termination provision or the remedy division, the cure provision means nothing. And everyone doesn't matter.
Well, I've been educating people on this for, really a couple of years, but now everybody's getting more educated on it. That, don't use MailChimp. MailChimp's unreliable. They're political. They'll revoke your access right away. Don't use a lot of the conventional campaign methods of either payment processing or other things if you can avoid it. Have backups. Have something else if you can. And they're going to lose business. Now, it's because Bezos and Dorsey and Zuckerberg care more about their messianic image than they do about making money. Maybe not Zuckerberg. There's an open question there. But that's why they're doing what they're doing. I mean, Zuckerberg goes out and admits, okay, yeah, our stock has dropped 12%, 15%, whatever it is. But, it was really kind of a dangerous thing that we did, but we're still going to do it because we're on the moral righteous cause. And not even be self-referential, aware in complaining about Uganda blocking you once you start doing this. I think Twitter did not expect the backlash. Like, they didn't expect someone like Merkel in Germany to say this is a dangerous thing. Didn't expect the president of Mexico, who's to the left, say maybe we need to get rid of social media in our own country because we can't. Everybody around the world was like, if you can do this to Trump while he's president, they expected them to do it to Trump after he was gone. Them doing it while he was president, they're like, hold on a second, you're not going to run our lives all around the world. So that's a no-go. And they overestimated greatly their position of power. They're going to start to get blowback, I suspect, not only from a bunch of politicians around the world, but from courts. We're already seeing it in a recent Canadian case.
Yeah, and incidentally, so there were some politicians who were critical of Dorsey and Twitter, but you got to love it that the government only gets critical when they realize that private enterprise has more power than they do. They want to be the ones, like China understood this a long time ago. You don't let Google or Facebook control it. You control it. Exactly. But I know it is interesting. The reaction was it was interesting, and we'll see if they learn anything, but they may not.
It'd be great if Parler wins. I think they should win because it will enforce that 30-day provision for everybody else and will not allow the big tech companies. A lot of companies have these exact 30-day language in it of either notice to cure or 30 days notice before they can terminate. And this was both. This was a hybrid of both. I mean, Parler, I see why now Parler thought they were safe. They had contractually negotiated for a very strong notice, not only a 30-day notice, but a 30-day opportunity to cure provision. And and Amazon wouldn't allow them to do either. Amazon didn't say, okay, you have 30 days to fix this or we'll terminate, or give them 30 days notice. Oh, we're going to terminate in 30 days either way. They breached both. And they're like, but judge, and not only that, here's the other problem. Factually, they're false. Amazon claimed that they misled the court about the way their relationship with Twitter. They pretended that they don't really quite have the server relationship with Twitter that they have by what the difference between hosting the feed versus hosting Twitter in other capacities. But the other component is they accused they did all these citations of problematic tweets. Almost every or parlays, as they're called in Parler, almost every single one is First Amendment protected speech. So like almost none of them were illicit incitement. Their language I don't like and don't approve of, but they're all First Amendment. None of it was go do this at this time at this place. And it didn't meet the true threats jurisprudence. It didn't meet the imminent incitement jurisprudence. And then it turns out, as Glenn Greenwald and others have documented, that it's Amazon's pals, Facebook and Twitter, where a lot of this was organized and worse threats were taking place. In fact, Amazon itself was busy selling "Kill Trump" T-shirts while they were bringing this claim.
I think it was Republicans. It wasn't specific to Trump. It was, kill Republicans. It was. I saw the shirt. Let me bring this comment.
By the way, for everybody out there, turns out no one that's been arrested used Parler.
Yeah,
so this whole allegation that we had to do this because of Parler was being used to create the second Civil War in America, and it turns out nobody that's arrested even used Parler. I mean, so even their messianic pitch turned out to be bogus.
I want to clarify this point, Paul. Think about that one, Viva. China is a good example of governance. That wasn't my point. My point is that that's a good example of tyrannical government who realizes that you don't want to let a private enterprise have more power than the government. And when they see, I don't think Merkel and I think it was Macron were criticizing Twitter because they thought it was an excess infringement on free speech. I think they're just criticizing them because only the government gets to make that type of infringement on free speech in their minds, not nobody. So China is just a good example of how they understood the power and they wanted to keep that power in order to keep control over the people. Someone asked about the two. Oh, sorry. Actually, it's a good point about misleading the court because I think they misled me and I may have reiterated or repeated that statement. In their response, they said, we could not have shut Twitter down because we don't host their servers. Or sorry, what did they say?
Host their feed.
They don't host their feed. Now, so that's not black and white. They do host
they have a much more close relationship with Twitter than they're suggesting. And so what they were making a technical distinction that's not a legally consequential distinction for their power in that relationship.
Okay.
And they're just hoping that the judge, but if I'm Parler, I don't really care about that so much. My point is solely, that's more of on the political rhetorical side. It's a simple argument. This was clearly a termination. If it was, it breached. The remedy is immediate injunctive relief under Ninth Circuit law. End of story.
Yeah, but now it's already been a week. So why haven't they? Are they going to have a viva voce hearing, or is it just going to be written pleadings and the judge is going to adjudicate?
Be up to the judge. I mean, these days they're doing hearings by Zoom. So the judge does a hearing, it'll be by Zoom. The older judges doing it by Zoom is a little interesting, but he could just issue a ruling on the paper, the way the judge did in the Lin Wood Pro Hoc Vice case, where he just issued a ruling on paper. So a lot of them these days are just issuing rulings on paper. So either there'll be a hearing scheduled this week, or the judge will issue a ruling on the paper this week.
Okay, and interesting. The thing that I forgot to mention, the third claim, which people reminded me, thank you, tortious interference with business expectancy. So I mean, that is, if we're ranking the claims in order of success, likelihood of success, you go breach of contract, tortious interference, antitrust, and so the thing is, like, they have to build the argument that the reason Amazon pulled the plug was to tortiously interfere with contracts that they knew or ought to have known were going to be in the works or were in fact in the works. And so the argument is going to be that Amazon knew that there was going to be traffic being driven to Parler by virtue of their canceling Trump on the platform on Twitter, and so Amazon comes in to sort of ebb that influx of traffic to Parler, thereby interfering with its contractual relationships. I mean, what do you think?
Well, I think that's why they did what they did. I don't think what they did was for the moral high cause they claim, because if it was for the latter, they would have given him some time to remedy. They did it because they didn't want. In fact, I think it's partially why Twitter jumped the gun on removing Trump. In part, they wanted to show their moral superiority to everybody, but the other reason was there had been rumors that Trump was going to use his Twitter account to get to sync Twitter. He was going to say on Twitter right after he left the presidency, "I'm leaving Twitter. This place stinks." You know, some Trump phraseology. It's losing money. It's a failure, whatever. And I'm going here to Parler, say, or wherever else he can cut a deal with, and that would have led to a mass exodus of double what Twitter actually lost. Twitter, it looks to me, lost about 10 to 15%. I know I lost about 15% of my followers that are now no longer on Twitter. About 30,000 people, give or take. And looking at others, it's pretty comparable. So that probably means somewhere around 7 to 10% of all Twitter users left or were shut down. But their bigger concern is not just the number of people who are no longer on Twitter, but over half of the users of Twitter interacted with Trump's account. The concern is the massive decline in use of Twitter. And people don't realize that often matters more than the number of users on Twitter from an economic stock perspective. And as we forecast last week, they took a massive, massive hit, as did Facebook. Took a massive economic hit. You can see, I think they didn't think the market would react the way it did. They didn't understand that not everybody's aligned with hey, be a messianic hero and sink the value of my stock. That this is the echo chamber that they're trying to create. The big tech oligarchs are themselves inside of.
It's interesting. Someone had just asked why Trump didn't take the precautions before, he knew that they were going to block him. I responded, I think it was silly. Something was the avatar. I don't think anyone thought they were going to do it before he left office. So it's the brass cojones that it takes to block the sitting president, even if he's a lame duck 2 weeks left. To do it to a sitting president, I don't think anybody thought they were going to do it. So it's not like you could prepare for that. And
I mean, it would be like if ABC, CBS, and NBC didn't. I mean, what if every method of communication was shut down and they didn't allow the president of the United States to communicate to his own citizens? I mean, that's the implications. And that was the implication that shocked a lot of leaders around the world. Not only was it that they think they should be in control of it, they're like the idea that some, Jack Dorsey, some, hipster homeless looking dude can decide that I can't talk to my own constituents. I don't think so. So I think they're going to get much more blowback than they ever anticipated. They don't have the alignment that they thought they did. And they're in political and legal trouble.
And we're counting the days down. I'm predicting it. It was your recommendation. I'm going with the prediction. They're going to face a class action shareholder dispute because they cost people money, real money, because of their virtuous regard,
and because they lied. They told the market, we won't do this, and then they did. So there's Section 230 covers a lot of sins. It doesn't cover lying and stealing from stockholders. That's one place where you don't have protection.
We're bringing this one up, and we're going to talk about it, I guess, in Rumble. Sorry, but their 230 defense, not a chance.
No. So Section 230 is not a defense to any of the claims that they're making. Okay. It's not because it's definitely, they admit it's not a defense to contractual claims. Trying to pretend, and this is a good bridge into the Rumble versus Google claim, what big tech still hasn't woken up to. Because what happened is big tech used Section 230 to mean something it didn't mean by interpreting it to say to courts, this is the politicians are on our side, so you better be on our side too, and just expand its definition to give immunity for almost everything and don't apply its plain language anywhere. Then they bought off most of the legal academy. Most of your law professor types who claim to be independent tech people are really just grifters or just prostitutes for big tech. That's all they are. If you dig into where they're getting funding for a wide range of things, who's their side clients, etc. So they're not accustomed to ever losing. And when you research the background of these big tech execs and the big tech founders, they're mostly people who've never lost in their lives. So they don't know what it means to lose. And they have grown very arrogant and completely disconnected. Part of what they've been doing is building their own echo chambers now for a decade or so. And the net effect of it is they don't realize that politically is that a lot of these decisions that were made by courts were political decisions, not really legal decisions. So an example of that is once the Department of Justice and all of the state attorney generals, or a bunch of them, started filing antitrust claims, that meant the courts were no longer going to look at those antitrust claims the same way involving big tech. That's why it's unleashed a flood of antitrust cases, of which Rumble is just the latest against them. And they've been doing things, as Matt Stoller and others have noted, and he's from the left, but he's a good antitrust guy, is that the things like tying are classic antitrust violations. And even though the Rehnquist, a lot of Republican Supreme Court justices have undermined antitrust law over the last 20, 30 years, one place that's still vibrant is what they call tying. It's when you use your monopoly to create an economic advantage in some other area. And that's what Google's been doing that en masse, but that's what YouTube was all about.
Well, so here, let's get into it, and I'll give the 30,000-foot overview. Rumble, everybody knows now, is sort of, it's a small version of YouTube. It's competing, and it's doing well. It's called the free speech YouTube. It works the same way. Creators can upload, they can monetize. CPM, cost per mil, is competitive with YouTube, if it's not virtually the same. And it's like it was cat and dog videos. It's been up there since 2013, but now it's sort of been the recipient of the purge from YouTube. So it's got a lot of conservative voices. Dan Bongino, Dr. Srinivasan, I think, a good doctor, Dr. Shiva. Okay, so now they have been trying to gain ground, and they've been gaining ground. They have just sued Google, alleging antitrust, and we're going to get into this because there's the Sherman Act and there's the Clayton Act, and I don't exactly understand how they work together, but I think I do, but we'll get there. They're suing Google for antitrust violations in that Google, which owns YouTube, which is owned by the umbrella company Alphabet, apparently tweaks the Google search engine to favor and prioritize YouTube search results to the detriment of other businesses. And so Rumble, which... it's a little complicated. I'm going to go through the lawsuit itself sooner than later. Today was just an overview in my vlog, but basically Rumble owns exclusive rights to some videos. They then syndicate them out to syndication partners who then run them on Yahoo, MSN, and YouTube. And the revenue that generates goes back to Rumble and for their clients. That's the syndication process. Rumble, which has exclusive rights to certain videos, once it publishes them on their syndicate partner platforms, sees that all of a sudden they don't even rank in the search engine, not for the search term of the video, but for the actual metadata of that video. So they upload it to Rumble, and then they syndicate it to MSN and Yahoo. This is from the lawsuit. They notice that in the search engines, it'll come up Yahoo, MSN, and I think Rumble as well, but not YouTube because YouTube doesn't have the video yet. Then they syndicate it through YouTube. Instantaneously, before the internet has collected any data, YouTube comes up as the first search result for the metadata, not for search terms. And Rumble doesn't even appear on the search results. Or if it does, it's after the 9th one, which is effectively not there. That's the overview. And so Rumble is now saying that this has cost them $2 billion in that they have not only been denied search results based on a skewed and trying to not use inflammatory words, but a falsified search engine which favors YouTube. It's like Google saying, "Hey guys, go to our other place," but not telling you this because that's the number one search result when it isn't. And so they get the financial rewards for that. They get the traffic, which stays because once you go to YouTube, on average, apparently you watch 9 to 11 videos. That would have otherwise been revenue for Rumble. And so they filed an antitrust lawsuit, and it's great. It's interesting. See where it goes. Did I miss anything in the summary, Robert?
No, that's pretty much it. I mean, basically what Google did is Google bought YouTube. And then they did what's called tying, which was using their control over the monopoly they have over searches. I think it's 94% of all searches are done on Google. That use their monopoly on Google to what's called tying to allow to increase profits for YouTube, a separate business or enterprise that Google now owns. And that aspect of tying is precisely what got Microsoft into trouble with trying to leverage their control over operating systems to force feed people to use their web browser rather than Netscape. and they ultimately lost. So tying is one place where our law has stayed strong. My own view is monopoly law was meant to prohibit monopolies, period. And this extra tying requirement was all superimposed by, frankly, conservative Federalist Society type judges who gutted antitrust law for decades. It's one area that, a lot of on the new populist wing of the Republican Party and conservatives don't realize how much the corporatist wing has done damage and favored these monopolists for forever, really dating back to the 1900s when they didn't agree with Teddy Roosevelt on it. So Teddy Roosevelt had to fight the corporatists in his own party to even pass any basic antitrust laws, where all these laws come from. So, but putting aside for the moment that aspect, tying is clearly illegal. That's clearly what Google is doing. They have example after example after example of it. And what they had is they have three nice claims. One, that tying is recognized as illegal antitrust violation under both the Clayton and Sherman Act. Second, though for different reasons under each statute, but that's what it boils down to. The second component is giving real-life examples of how that worked and showing it to the court so the court can see it and witness it right within the complaint. And third was excellent citations to remind the courts that the politics has changed. Number one, citing the Justice Department's own antitrust complaint. Number two, citing the House committee's conclusions that included Democrats about the problematic antitrust monopolistic behavior of big tech. And so if I'm a judge, I see a very different political environment that, frankly, Facebook and Twitter lit on fire by canceling the president of the United States while he was president. So they clearly, they don't take seriously the antitrust claims against them, just like Bill Gates did. Bill Gates didn't take it seriously until he was about to lose. It was his complete disaster of a deposition performance where David Bowie's actually did a very good deposition of him that started to enlighten him to the reality of it. And he later admitted it did a massive blow to Microsoft's ability to dominate that area of space that it planned on dominating, and believes it would have, but for the antitrust claim. These antitrust claims have from the Justice Department and the state attorney generals have a very good chance of going forward, even if the ship has sailed and the Biden Justice Department being able to pull it back, because state attorney generals have joined it and it will look really bad at this stage. And big tech thinks because they'll have a bunch of cabinet positions that now magically these judges will still go in their way. And I think they're going to discover otherwise. So they may win here or there, but they're going to start losing. And they're going to start losing in court, in part because the law is clear. And they've never extended Section 230 this far. They've never extended other exceptions or exemptions this far, but mostly because the politics has changed. You have congressmen, you have senators, you have the Justice Department, you have attorney generals saying these are bad actors. Now you have presidents from across the political spectrum, left, center, and right, condemning them. They because the courts let them get out of hand, they're like a spoiled kid who finally went too far. And I think not only does Rumble have an excellent case, some questions the damages, but on the low end of their damages, I mean, their point was that they make 40 times more, but for this tying in on the low end. And their argument was they would show up more in other algorithms and other things. But even independent of that, they have at least a $400 or $500 million claim, even if they don't get into the $1 billion category.
And that's
and remember, in antitrust, you get to often, depending on the nature of it, you get to treble damages. So that means you get whatever your damages are, double it, plus you get your attorney's fees.
And that's one thing to appreciate also is that by shifting the traffic to YouTube, not only does Rumble not get that revenue, but what was the other thing? That Rumble itself runs ads. And so they are being deprived of the traffic that would otherwise generate revenue through their own ads on their own platform if the search results were, in fact, organic, interest-based, and not skewed by one company in favor of the other company that it also owns.
The other great thing it reminded everybody of is YouTube was not a natural monopoly. The YouTube was an artificial monopoly created by Google. At the time that Google bought YouTube, there were 6 or 7 other comparable competitors. It was only because of Google's tying that YouTube ever achieved the monopoly status that it did.
What was I was about to ask one? Oh yeah, sorry. Can you clarify the difference? What is the Sherman Act to the Clayton Act? And I think I understand it. The Sherman Act is antitrust. Clayton sets out specific types of antitrust conduct that is specifically targeted. Is there anything more to it than that?
It should have always been interpreted broadly. No monopolies. Period. That's my. If you read the plain, that's how it reads. The court started gutting it in different ways, and so they provided for specific provisions to make sure certain acts, certain courses of conduct were clearly punished. But otherwise the statutes are read in congruity with one another to meet the ultimate purpose of preventing monopolies, period. In the modern legal judicial environment, it's preventing monopolies that abuse their position of power through things like tying and things of that nature.
And incidentally, in the Rumble lawsuit, but it was also in the Google antitrust lawsuit, which I also did a video on, they specifically talk about the tying that Google requires Android to pre-install and not be able to delete certain apps, and forbids including other apps. So
they use two things. They use their search engine domination to tie in YouTube and create a monopoly there, and abused one monopoly to create a second monopoly. Then they use their de facto monopoly with Apple over apps and over phone systems to create another monopoly, both for themselves and for YouTube. And this is part of what's been documented by the Justice Department attorney generals as well. So, I mean, these were, whenever I hear these, Reason publication, which is really the Koch brothers and Robbie Sove, and who's really just a grifter for big tech. It's all he is. He should be honest about it. Quit lying to the world, pretending he's independent, intellectual. He's just a hack. These are people that, all the Koch brothers, it's the reason why the Libertarian Party is mostly a waste of time. They're mostly corporate spokespeople just in the name of liberty, but it's funny which liberties they come to the defense of. All of Google is not a natural monopoly, and nor YouTube is not a natural monopoly. They have leveraged all of their other monopolies to create more monopolies than existing monopoly power. And that's what happened. And this was not a market outcome. This was monopolistic practices that was in violation of free market principles, not a reflection or expression of it.
Okay, amazing. So, and everyone stay tuned, because I'm going to do a breakdown of the lawsuit. I don't know if I'm going to get an interview with Chris Pavlovsky, the CEO of Rumble, not because I couldn't get one, but I don't like talking with parties during pending
litigation. Yeah.
So let me bring up one chat, because it's an interesting question. Jason L. Why has nobody approached this from a human rights angle? Free speech has been affirmed to be a human right by numerous international agencies, agreed to by many nations, including U.S. and Canada.
It has been in Europe on right to privacy and other grounds. What it is we just don't have any enforceable human rights laws in the United States beyond what the civil rights laws that exist, and they only apply to state actors. That's why. All
right, and I think we've covered Rumble. It's actually, stay tuned, because there will be follow-ups for certain, and it's going to be an interesting suit. It's great. So if you haven't seen it yet, I put up an overview today.
Two great opportunities, the two best opportunities to take on big tech, other than the antitrust claims brought by the governments.
Fantastic. Let me bring up these two super chats. How do you feel about the FBI? Okay, well, we'll stick to certain topics and just bring them up because I'm here. One other super chat, which I feel morally obliged to respond to, because when they come up in red, it was, for goodness sake, I can't bring it up anymore. I think it was McConnell. I think the name was McConnell, asked about Pudge peeing down my leg. In one of my videos where I was talking about the curfew, I made a joke about some warmth on my leg. It actually wasn't pee, it was poo. It's even worse because it sometimes just comes out like that.
Any worries that they won't consider you? Have you looked up the law of what it means to walk the dog?
That's it. I was thinking, that was a joke, because I'm carrying the dog, so I'm not walking the dog. And if the dog is admittedly paralyzed in the back legs, how can I walk a paralyzed dog? I do have wheels for her, but I want her to walk on her legs to build the muscle. Okay, this might be a good segue into the impeachment. So people can get updated on the impeachment.
Maybe just one other good Canadian suit that in your neck of the woods brought up by one of the locals board members, just sort of briefly, but it is very interesting. It correlates to some of the issues raised in the Covington cases that I have. I may actually use it as a persuasive citation, additional supplementary citation for the court in that case, which is that someone has sued Twitter in Canada, where there is no Section 230 immunity, on the grounds that internet defamation allows suits of Twitter in Canada, and the court found jurisdiction applied in Canada. And what that could mean, and I think is what we talked about last week, that international jurisdictions often have better law for suing big tech than here in the United States. And because so many of these, because Twitter and Facebook and Google, YouTube are so global, you can sue them in other jurisdictions, and the European countries have had success going after big tech just on privacy issues. You have Poland, other places that are banning censorship. If you censor, you can be fined, criminally prosecuted, etc. I think that may be where there's more remedy, and we're seeing the first example of that as well in Canada, where Canadian court said, yes, you can sue Twitter in Canada for somebody else lying about you on Twitter, because there is no Section 230 immunity in Canada, and there's no First Amendment speech protection in Canada. I wonder if some of the social media lefty fans of these speech codes are going to be as happy when they're facing those jurisdictions in Canada that don't have such First Amendment free speech protections.
It's very interesting. No, I haven't actually read that decision. You sent it right before, and I'm going to read it soon. But how did they get past what I presume was the argument on venue as per the terms of use?
Because the person's not suing based on Twitter doing anything to them in the sense of customer service. They're suing Twitter because they're saying Twitter defamed me because this statement was made by somebody else on Twitter. So thus the terms of service doesn't apply. It's not a breach of contract claim. Okay. And so you can't bring that claim in the United States because of Section 230 and the First Amendment, depending on the circumstances. But you can in a lot of foreign jurisdictions. A lot of them just had found reasons not to do so. Now this one does. And like I said, I think it's all a reflection of Twitter going too far and showing, hey, you know what? We run the world, but we do so for your benefit. Turns out the world on all sides politically doesn't like that idea so much.
That's an amazing argument in Twitter, because it would seemingly also apply to YouTube if anybody wanted to sue YouTube in Canada, which has
better be careful about saying anything bad about Viva Fry.
Because my dad has a lot of time on his hands now, and he was looking for a good lawsuit. Yeah, that's interesting. That's actually I'm gonna read that because I've been curious as to how they get around it, and they're gonna say, yeah, it's not our terms of use because you weren't a user. I was not a user, rather, I was just a victim. So that might exist between you and whoever posted it, but I'm holding you responsible. That's very interesting. And if anybody thought that they were, lax on defamation in the United Kingdom, may I remind you that Mike Ward, a stand-up comic in Quebec, was fined $43,000 by the Quebec Human Rights Tribunal for a bit he did on a kid whose name was Jérémy Gabriel, and his stand-up bit on the kid, which the Quebec Human Rights Tribunal found violated his dignity. So we have some very expansive laws on what can and cannot be said without potential repercussion. This is not an affirmation or an agreement. It's just different laws, different countries, and you start getting sued in those countries. It's a different ballgame. Okay, Robert, what do we make of Trump's second impeachment?
So I think, to me, holding a trial for the president, I think the impeachment is unconstitutional itself, but I think that the holding a trial would be patently unconstitutional. So Dershowitz has the same opinion on this. Turley has the same opinion on this. Other professors, at least in the past, did. We'll see how many of them are willing to voice it on Trump's behest or behalf now. First of all, the Constitution is clear. You can only impeach someone for who is holding an office. And the Constitution says this twice. And so the idea that they can hold a trial for someone who's not holding office is not within their constitutional power. And the Constitution says the impeachment power extends only to these circumstances. And one of them is not ex-office holders. So that's problem number one, and why it's unconstitutional. Problem number two is it's a patent bill of attainder. So the legislatures of Britain, the Parliament of Britain, used to try to criminally punish and prosecute people themselves, independent of the judicial process. This was hated by the colonists. So one of the things included in the original Constitution, even before the Bill of Rights, was there can be no bill of attainders, period. What that means is the legislature can't go around punishing people as individuals, period. They have no power of punishment over a person, period. Their only power of punishment is removal from office. That's all. And it's from the federal office. So there's a power of expulsion in the cases of members of House or the members of the Senate. And there's powers of impeachment involving the judiciary and the members of the executive branch. There is no power to punish otherwise. In fact, it's a patent constitutional violation. So clearly, punish Donald Trump when no longer president is a bill of attainder within the meaning of that constitutional provision, and as such is a second violation of the Constitution. The third violation is that this is a violation of the First Amendment, because they're to punish Trump for his speech. And the First Amendment applies to any governmental action by any governmental body at any time. This includes congressional subpoenas, or any other congressional enforced action, which cases punish the president, in particular, deprive him of the ability to future office. That power only exists. It's in the, as Dershowitz noted, it says you can remove an officer and bar them from future office. It doesn't say remove them from office or disbar them from future office, as if the latter could be a power for the former. It's conjunctive. So they're trying to punish him for his speech. And it's clearly constitutionally protected speech, as both Dershowitz and Turley have pointed out. But others that have looked at it, it's patently obvious that it is. Because he gave a speech where he said, in order for speech to be criminal, to be within true threats or imminent incitement, it has to expressly call for unlawful behavior that can imminently occur and that you seek to imminently occur. Unless it has all of those components, it's constitutionally protected speech. The seminal case in this regard is Brandenburg v. Ohio, unanimous decision where the Supreme Court said calling Klansmen, talking to other Klansmen, calling for physical violence against the neighboring African-American community was constitutionally protected speech because it did not have the imminent component. In Trump's case, he never called for any unlawful action of any type, just the opposite. He called for peaceful protesting, patriotic protesting. That's not calling for illicit action. So they have no express call for illicit action, number one. Number two, it could not have been imminent because the people Trump was talking to were 45-minute walk away from the Capitol. And in fact, the Capitol breach began to occur while he was still speaking. So the speech couldn't have caused the riot, and so there couldn't be imminent incitement, period, just as a matter of geographic and temporal reality. And then third, we do know as a matter of but-for causation that the speech had nothing to do with the raid. The people who raided the Capitol had planned it in advance, and were doing it while the speech was ongoing, while people from Trump's rally could not get there to stop them from doing so. Were done so often with the facilitation and enabled by police action and FBI action in the sense of what they chose to do or not do, and warnings given, and policing tactics and security tactics taken. And now we know, of course, there were other, BLM, Antifa types involved in it, facilitated it. One has now been charged. One who was celebrated by CNN as an independent reporter. CNN put him on there. And of course, now he was calling for burning down the Capitol. That's an example of illicit incitement is what that BLM guy is being charged with. Because while they're in the Capitol, he's encouraging them to do criminally illicit acts right there and then. That's an express call for illicit action that has the imminent capacity to occur. Though it's far from clear that hardly any of them were inclined to do so, because I don't know if you saw the video with the Vikings guy. It turned out part of his defense may be right. It appears he was escorted in with the Capitol Police. And they're all sitting around chilling out. And he's like, hey, everybody be cool. And he's like, yeah, we're cool. And we don't want to cause any problems. And can you leave the Senate? Yeah, we'll leave here in just a second, dude. I was like, I mean, this would be like if the Big Lebowski organized the Capitol Hill riot. I mean, this is not a real Capitol Hill. This is not a coup. This is not an insurrection. There was a small group of QAnon and other people who try to cause problems, but the bulk of the crowd was just, walking between the lines, looking at the pretty art, or the Vikings guy who just wanted to sit up on the Capitol sit up on the Senate chair for a little while. And wrote a bland statement about, hey, justice is coming, and that's what they're going to try to prosecute him for. That's not a sign. Does anybody really think that guy wanted or committed imminent criminal incitement? He's clearly been duped by Q. He calls himself the Q shaman. But by no means is there any evidence of imminent violence in his conduct, at least.
There were some videos that were showing, actually, I mean, for what they're worth, the media doesn't play them as much as they might otherwise, but of supporters telling people to stop breaking windows, where you saw a guy smashing a window. And so for anybody who doesn't appreciate this, Trump has been impeached on, I believe it was called inciting an insurrection. Those were the formal charges. How long did it take them to draft and approve those second impeachment charges?
I think it was like 12 hours total. Because first they try to invoke the 25th. These same people that pretended that the reason why they had to vote the way they did on the election contest is because they're deep believers in the Constitution. A Constitution they mostly ignored in its history and its application in that precise electoral contest area. Were the same people that suddenly wanted to invoke the 25th Amendment to remove a president who's clearly not incapacitated. So it's a joke that these people were trying to enforce the Constitution at any time. It's a crock. And their attempts to gaslight the world otherwise is just ludicrous. They're like Jack Dorsey of Twitter and Zuckerberg with Facebook. sitting there thinking the world wants us to do this because their little cocktail party, their little martini get together said so, on maybe a martinis via Zoom these days. But they had no idea that this is not where the ordinary world is, and they recognize nonsense when they see it. That's why legitimate public opinion polls, not the fake ones that are trying to gaslight people, show Trump doing just as well as he was before. They're not accepting all this. Like even the NBC poll said, how serious is this? Does this rank up there with 9/11? Does this rank up there with the assassination of President Kennedy? And people are like, no. Only the hardcore lefties on Twitter, the AOC fans of the world, thought this ranked as anything serious. They see the Viking guy and they're like, not good, the Viking guy sitting in the chair, but no, I'm not going to have a heart attack over it.
And incidentally, CNN, who initially reported that there was that authorities or somebody had confirmed that there was an intent to kidnap and do worse, they walked that back in a piece that nobody's going to see. And my brother said
that's because the Justice Department leaked out some nonsense because of how politicized they are, and the FBI rebutted it within an hour. Because the FBI is investigating in this. So what they're finding is there's some QAnon types, there's some Boogaloo Boy types, some Antifa BLM types, and that basically they were the ones orchestrating this, trying to use the cover of a rally to try to break into the Capitol. And there was a few of the QAnon types who really thought they were working for the government, that the military and police were secretly on their side, and that they were being deputized by their Q oaths to go in there and operate. And that's the reason why that poor woman died. It's the reason why other people died there that day. So I mean, it's a tragic event, stupid violence, but by no means was it. The insurrection language comes from way back after the Civil War, wanting to criminalize someone trying to literally restart the Civil War. It was not meant to apply to political speech. And reinvoking the insurrection language, reinvoking the sedition language, it's always been misapplied to politically dissident speech. It's almost never been applied, once or twice to actual terrorists. But otherwise, it's being misused and abused, and they're using it as a pretext for new speech codes and new monitoring and new surveillance and Patriot Act on steroids 2.0, where they're going to label people domestic terrorists simply if you showed up at a MAGA rally. I mean, that's where they're trying to go.
And we're seeing it already. It is Orwellian 1984 rubbish, for lack of a better word. Now, Alan Eaton said at Viva, Congress has impeached someone out of office, William Belknap, Navy Secretary.
Yes, but the Senate acquitted him on the legal, not because he was innocent of the facts, but because legally they said they had no jurisdiction to try him after he was out of office. So the only precedent on this is the acquittal of Belknap. That's a cabinet official, and that's the only one I know of. And there's some arguments about whether there should be a different. Generally, it was supposed to be harder to impeach the president than either a judge or a cabinet official, but that's another matter historically. But again, this is a bill of attainder. If you can say simply if you've ever held federal office, we now have the power to bar you from ever running for office. That is never what an impeachment has ever meant historically through the entire history, going back to the English age. So this is a radical departure from the Constitution, a radical violation of its core principles. And the fact that it's being done in violation of the First Amendment and free speech makes it even more offensive. And arguably, it's a violation of due process under the Fifth Amendment because there's been no hearings, no opportunity to contest evidence, nothing else. I think the president may bring suit in federal court to challenge the entire trial. We'll see. Some senators are realizing that this is backfiring. Mitch McConnell and his continued cluelessness and his in the turtle senility in his last term he really thought that if he leaked that 30 or 40 House members were going and that he himself was thinking about saying yes to impeachment, that he was going to get Nixon level 1974 numbers. And instead, he only got 10. And there are 10 whose days are short. Over a majority of them won't even be back next term. Including, and it'll be a beautiful, righteous thing to witness, the end of the Cheney family to go along with the end of the Bush family when Cheney gets whipped in Wyoming in 2022. But because of that, McConnell, all of a sudden, right after that, Tim Scott comes out and says, it's not such a good idea for us to do impeachment. Lindsey Graham comes out and says, we should just dismiss this. This doesn't look so good. Rand Paul's like, this is going to break up the party. So McConnell is completely losing power. He completely misread the environment. And the establishment's goal to ruin Trump is already dying on the vine But the fact that we have one more attempt to violate the Constitution in the name of going after Trump is one more embarrassment of the attacks on Trump in the Trump era.
You could still see me, Robert, right? Someone said that they couldn't see or hear me.
Oh, I can.
Okay, perfect. I had another question about the impeachment. It was, there's no strategic benefit to go to the trial and Trump appears at the trial to testify on his own and send a political message where after Twitter shut him down, it might be his best venue.
It would be a little risky to testify because that's always under penalty of perjury. So why set yourself up for something that somebody can make hay out of? My view would be to challenge it in the courts first, and see if the courts, see if the Senate delays it. I mean, the Senate should do is just dismiss it and be over with it, and recognize they don't have the power. I made a forecast on our locals board, vivabarneslaw.locals.com, where we provide both general and some exclusive content. There's an episode of Hush Hush people can watch to see my full views of what happened on Capitol Hill, and the rest. But if you deeper, I think that in terms of the approach to be taken is better that they move to dismiss than partake and participate. I did predict on the locals board that if Biden was politically smart, it would be like Biden to want to make a grandstanding moment and say, let's drop at his inauguration on Wednesday, say, let's move forward. It's amazing. You do something crazy unconstitutional, your party does, and then you show your unifying gesture just by not torturing the Constitution some more. But it would be politically smart for him to do. It's politically not good for him to have the Senate consumed for weeks, maybe months, with an impeachment proceeding while he's trying to get any legislation through. I mean, it's the political ineptitude here is off the charts. It's because of how greatly they fear Trump. They fear that Trump will come back in 2024, and they're trying to prohibit that. The problem is if it's unconstitutional and the Supreme Court does its job, always a big risk, then it won't matter because the Supreme Court will say, no, the Senate couldn't do that. And so he can run anyway. So why? And then you've made Trump a double martyr. You illicitly impeached him, and then you illicitly tried to bar him from office. You give him even more political juice.
Well, and I'll read this from Cleopatra. Says, my last chat just to aggravate the liberals who have infiltrated. So the Senate cannot vote to impeach due to no precedent. They cannot vote to impeach because it would be unconstitutional. The only precedent is anybody who's been...
There is no, contrary to what people have said, there's a majority vote in the Senate that said they could, but that's not how impeachment proceedings work legally. It's what the vote on a conviction or acquittal is. And the acquittal took place because enough senators said, no, we do not have the jurisdiction to try someone after impeachment is gone. I mean, when you have Turley and Dershowitz both on the left say this is obvious, I mean, they're like, come on. I mean, that gives you an idea for what an honest constitutional analysis. It's never been done, in my knowledge, anywhere in history that someone has been with comparable impeachment provisions.
I want to highlight the two things that I find to be the most shocking about this from an outsider perspective is how quickly it took them to draft and approve impeachment articles from what I understand, it took months if people have even gotten COVID relief in the first place. So you can get this done within 3 days. But when people are out of work and shut down and they can't even get basic subsidies, it takes months to do that. That was my first thing, which I found offensive as an outsider. The second thing, from what I understand, if hypothetically Trump is successfully impeached and confirmed by the Senate, it's not just that he can't run for office again, which would be one victory. From what I understand, his security detail would also be removed.
Yeah, it can be. Yeah,
and so I mean that's
a little bit up in the air. It can be grounds to deny him. The Secret Service can provide, like the Secret Service provides protection for people who are just presidential candidates, for example, who are not even federal office holders, for family members of elected officials. So they have broad authority, but it can be they don't have to provide it, is the interpretation, if he's impeached.
Yeah, I thought that was the most disgusting of the potential, call it objectives in pursuing impeachment, is to A, just persecute to the end, B, try to have it so that he can't run for office again, and then C, try to have it so that after all the vilification, his Secret Service detail is eliminated because of the impeachment. I thought that's what I found to be the most distasteful potential outcome.
And the leading foreign policy publication called Foreign Policy by the national security establishment just called for, quote, the elimination of populist adversaries like Trump. And, that language surely doesn't help. It's interesting that the people using that language are attacking the president for calling for a peaceful, patriotic rally. I mean, it shows the gap. It's a accusation through
confession through projection. Yeah, I don't think there's any question. I have my own theories, but I'm thoroughly convinced social media, in blocking and doing what they're doing, purging, every fear hides a wish. David Mamet. We fear this, but my goodness, if it happened, it would give us great justification to impose further purging. It would give the government great justification to impose further strict laws. We can criminalize, qualify as insurrection just based on political affiliation, and there goes your right to protest, just like that.
And it's designed, I think, to trigger a bad reaction in the public that can be then used to justify further crackdowns.
Oh yeah, and by the way, I forgot to mention one thing. 12,000 people watching. Hit the thumbs up button. You can also drop a comment, but hit the thumbs up button so we can see it go from 3.2 thousand to 6,000 in 30 seconds. Let me bring up some chats while we segue into another discussion. Oh, no, wait. One more question on that. The R Heretic says 20,000 troops guarding a supposedly legitimate elected president and Congress that's backed him during an inauguration without people. Barnes still think we'll have a legit elections in the future.
Yeah, I understand that people are looking at what's going on and they think that the end is nigh. I'm not of that mindset. So that doesn't mean you don't prepare. I've been telling people for decades to have a plan B. They just look at the history of governments and societies. When they collapse fast. So you should always have a plan B to the degree that you can. And people can have greater plan Bs than they think. It's not always contingent upon certain plan Bs are contingent upon resources, but not all plan Bs are. But look at what's already happening. So, what happened to Twitter and Facebook and Google have functionally been immune for 2 decades. And now they're facing the biggest, most plausible causes of action against them in multiple jurisdictions they've ever faced. So the idea, this is over half at least half the country is on the populist side. And frankly, even a lot of people that voted for Biden oppose these kind of big tech censorships efforts, oppose fraudulent elections, oppose a lot of these things. So there's a lot of remedies still available. The fact that they had to beg a bunch of National Guard people to show up to make Biden feel good about his empty inauguration is not a sign of strength. That's a sign of weakness.
Okay. The next step then in the impeachment, there's no trial period. Senate's not even sitting. So what's going to happen? Are they going to decide when they reconvene?
Yes. So McConnell said he wasn't technically they reconvene on the 19th, but McConnell made clear he wasn't going to do anything with it. Graham is trying to ask him to bring up a motion to just dismiss it before the 20th even occurs. That may or may not occur, may or may not happen. I think there's pressure on it, but then we'll see if Biden says anything about it. If he's dumb and allows it to keep festering, then I'm sure Schumer has all the political desire to pursue it. And then some sort of trial will happen, but it's almost guaranteed to be an acquittal. Some people will vote acquittal on factual grounds, some on constitutional grounds, some on the grounds they don't have jurisdiction or authority to hear it, and that'll be the end of it. Unless the president sues before then and moves to stay the entire trial on the grounds that this whole thing is unconstitutional. And I know that Giuliani has thought about that possibility. I know that I don't think Giuliani would necessarily be the guy to go forward. Some people have asked, there's a chance I'll be involved. I don't know yet as to whether or not I'll be involved. Happy to help in whatever way I can, because I am constitutionally offended by this process of what they're trying to do. And I know Dershowitz has suggested that as well, to sue first and to go to take it up to the U.S. Supreme Court, see what happens. But we'll find out. Again, if Biden is smart and the Democrats are smart, they'll have already played their hand. They'll know where this game ends, and they'll make a grandstanding effort at the inauguration to, quote, heal the country by moving past Trump. If they're dumb and foolish or more ratings driven than substantive driven, they'll allow this to get dragged out in ways that will ultimately undermine Biden's ability to get anything done. And he's wanting to do crazy things out of the gate. He wants to give every illegal alien automatic citizenship. He wants to write $2 trillion worth of checks to everybody he possibly can, especially all the people that line up. As you go back, those bills take a while to get through because, hey, grifting is hard work. So when you're out doing the shakedown effort, that takes time. You got to talk to this lobbyist, that lobbyist, who's going to give me this, who's going to give me that, who's going to give this kid a job, that on a job, that parent a job, that relative, that friend a job. And the rest.
Now, two people have asked the same question actually in tandem. Cleopatra and where was the second one? Michelle Sponogli. What's a viable plan B? And funny thing, like, and I was having this discussion earlier. When the banks, when you see banks saying they're no longer going to be doing business with Trump, and you see that they might have this willingness to cut off ties, funding, financing, what can you do? When under the guise of quarantine, passports can be seized and confinement can be ordered. Robert, what is your viable plan B?
I mean, that's really all dependent on the individual, their preferences and their resources. So I've been doing that legally for clients for 20 years. So and for reasons that should belabor the obvious, I don't generally go into general detail about what the most effective plan Bs are. I'll provide general information and general guidance as to its utility and to where it can be helpful. But for those who have the resources, multiple forms of citizenship with travel and passport accesses to multiple nations, not dependent on any one country's papers for your legal rights and protection is obviously always beneficial if you can afford it. I call it jurisdictional diversification, having as many resources in as many places by as many means and methods as you possibly can. And frankly, that's something even the ordinary person can do. The ordinary person can have a little bit of Bitcoin, can have a little bit of cash, can have a little bit of barterable items, can have it in different places and physical locations at some level. Or I used to call it a travel bag after the movie Heat. So that'll be our first cinematic reference.
I quoted that one in the intro, actually.
Hey, there you go. The never have anything in your life that you can't walk out on. It's a line that you can't walk out on in 15 seconds flat if you feel the heat around the corner. I used to say, be prepared to be able to walk out in 15 seconds flat in case you feel the Gestapo around the corner. And that's having a good travel bag. And a lot of that is planning frequently. A lot of it's not just a matter of resources. And cinematically, you'll often see this portrayed in a wide range of films. So if people want to know where I get some of my ideas from and other places that they can get good ideas from, look at films where somebody has to be on the lam for any reason. And because cinema people are trying to draft something and write something that's realistic and that's believable, they often actually hit it on the nose. Sometimes they'll miss it here or there, but often you'll get great insights. There's a reason why Bourne Identity has the little travel bag that he has: multiple passports, multiple cash, multiple currencies, multiple means of communication, multiple means of travel. And so people can have that. People can have a little bicycle, a motorbike. Maybe it's something cheap like that, but something that's not necessarily registered in their name with a different license plate on it, that boom, you can hit the road if you got to hit the road, that has a little travel bag in the back that has an independent means of communication and enough currency to get to where you need to go. Everybody can stack skills. I mean, this is a Scott Adams advice, but I always say it's good to have portable skills, everyday skills that are universally valuable. You don't need a fancy degree for that. Learn to be a mechanic. Learn how to work maybe something with computers. Learn how to do certain nurse level of medicine. There's a wide range of universally desirable skill sets that if you have, you can get anywhere you need to and be able to make a living. So those are some of, and then there's other basic ones. But for everybody, they should start getting independent technologically. In terms of, Signal is a big improvement, or not necessarily perfect, but a big improvement over the alternative as a messaging app as one example. More use of blockchain to create independent means of communication that are outside of the server environment. That's good. Not relying upon the big companies in terms of Amazon or MailChimp if you run a business or you have an email company or anything like that, or need email in your business. So all of those will be components of it. People are going to learn a different, more sophisticated level of survivalism, of how to be as independent from the controls of the oligopolists in the state as you possibly can, because they're being awakened to it, frankly, too early. The system would have been better slow burning the frog, not turning up the heat so fast.
And it's an interesting thing, actually, the talent stack, as Scott Adams puts it. But the reality is, if you can't find a plumber, you can't find a brick worker now, and to the extent that you have those certain skills which are going to be fundamentally required at wherever you are, nobody's going to care about politics. So getting canceled on social media when you are a social media personality can be devastating. When I don't want to pick on PewDiePie just because I don't know what his other skills are, but he might have enough money for the rest of his life anyhow already. But if you get canceled, it'll end that source of revenue. But for me, if I have to go back to law, I always have that skill, and the world always needs lawyers, even if they don't want them.
Yeah. And there's skills that go with it. A lot of people have asked me, should I go to law school? A law degree is always worthwhile. It's always been a good economic investment. It's a safety net, if nothing else, as Viva just pointed out. And on top of that, it teaches you a certain strategic skill set. And even though the left has sort of, in my view, contaminated and infected the law with ideas that are contrary to the rule of law, the way the law is still currently taught, for the most part, it still follows a rule of law principle. So those are good principles to learn. Ways of changing your motivated thinking. In other words, by the adversarial process requires that you change your motivation to improve your reasoning. And it's a great skill set to acquire, period. So there's a lot of skills that go with that are universally useful and applicable outside of the context of the legal profession itself.
And speaking of motivated reasoning, good segue. It's not something we have to spend too much time on. The motivated reasoning, or what I perceive to be the motivated reasoning in the judge's revocation of Lin Wood's pro hac vice authorization to represent Carter Page. We talked about this, I guess it was 2 weeks ago now. On paper, it looks like you might have been wrong on the assessment in that Lin Wood raised what you said were going to be the grounds of defense, that the accused acts did not occur in or before the court in Delaware. For anybody who doesn't know, I'll back it up a little bit. This is not going to be a rag on Lin Wood situation at all. I think, in fact, Robert and I are probably going to come to his defense to some extent. Lin Wood is representing Carter Page in a defamation lawsuit against some company, I forget what it's called, in Delaware. 2 weeks ago, January 6th, the judge in that file issued an order to show cause why the judge should not revoke the pro hac vice authorization, which is a one-time permission for a lawyer to represent a client in a state in which they are not members of the bar, for the purposes of that one file. Lin Wood got the authorization. The judge said, I'm seeing what's going on in all these other jurisdictions in these frivolous lawsuits that you filed over the elections lawsuit, over the elections results. Why should I not revoke your authorization that I gave you? And here's an order to show cause. So tell me why I shouldn't do it. Lin Wood, an hour left in the day that was the last day to file his response for the judge, filed his response. The judge remarked on that in the judgment, but ultimately revoked the authorization, said, what you did in Georgia, what you did in Michigan, unforgivable errors, negligence, mendacious conduct, which means not only untruthful, but having a propensity towards not telling the truth, and revoked his authorization. Lin Wood raised the argument that nothing I did was before this court, before this jurisdiction, and was not no ethical violations. And the judge basically said, I don't care that it wasn't in front of me. I don't care that they may or may not be ethical violations. That'll be up for the ethics court. My job is to uphold the dignity and the what's the word? Another word. Let's just say dignity of the court. I don't think you're worthy of the authorization I gave you anymore because of this conduct, which I don't like in these other court files in these other jurisdictions. Revoked. How do you, I mean, does it go to appeal? And how do you feel about the judgment? Does it go to appeal? If it goes to appeal, any chance of success?
Yeah, there actually should, on paper, be a high chance of success because of the political nature of the case. It may not happen. And I'm not sure how clearly and cleanly Wood addressed one particular issue. The main problem with the judge's ruling is that if you're initially deciding whether or not to give someone pro hac vice, you have complete discretion. However, once you've given it to them, they now have a cognizable property and liberty interest under the due process clause, and you have to give them due process. Now, the judge says he's given them due process, but there's a substantive component of that historically in the pro hac vice, which has been that it has to relate to something that happened before that court. Because otherwise, the problem is the court is stepping on the authority and power of other jurisdictions that apply real due process, because there wasn't real due process here. He allowed him to write a brief. He didn't have an evidentiary hearing. He didn't allow for testimony to be presented. He's adjudicating other courts' claims which have not also reached any full due process of the proceeding. So there's huge problems with courts deciding, I'm going to go and decide whether what you did over in that court was unethical and mendacious. He also contradicts himself repeatedly. He says, let me talk for several paragraphs about something that had absolutely nothing to do with what I'm saying here.
I mentioned that in my assessment. At the end of the judgment, the judge says, it's also been brought to my attention some troubling tweets, which I won't mention here just to keep this green lighted. That didn't form part of my consideration or judgment, except it formed part of his judgment. Whether or not it was his consideration, you don't mention something in a judgment if it's not to be considered part of the judgment. So Yeah, it was a little motivated reasoning.
So my view is he didn't establish why he has a jurisdictional nexus to decide pro hoc vice. So in my understanding, I mean, is from litigating this in other contexts, I know of no court who has ever revoked a pro hoc vice appearance based solely on allegations of another court. Now, there's some that you can revoke pro hoc vice when they've been suspended by another court or something like that. But here there was, in fact, there were no factually specific citations that he referenced in these other proceedings to Wood himself. Instead, he said, well, there are some statements made of these pleadings. Your name is somewhere on the pleadings, so I'm just going to assume you're liable for those statements while pretending that I'm not actually adjudicating whether you're liable for those statements. He admitted that all the law says that he has no business disciplining lawyers, that that's the Delaware Supreme Court's job. He admitted that he has no business disciplining over a case. That's the other court case's job. He just pretended he wasn't disciplining him. The problem is I did not see any meaningful analysis of how due process constitutionally applies. And now I don't know if Wood raised that very well, but I assume he did at some level.
Yeah.
But that would be my view is that the revocation of Wood's pro hoc vice violates due process because it doesn't relate to something that happened before that court for which it has authority or jurisdiction to look at.
And I just want to bring this up. Lade Phoenix says, thank you both and all your support staff for the great info. My support staff consists of my wife and 3 kids. And, oh, no, I shouldn't say that, actually. Eric Hunley, up behind the scenes. Nate Brody, who I bounce ideas off of. Robert Barnes, who obviously gives me, a tremendous amount of information. I didn't read the briefs, but from the judgment, it sounds like Wood focused primarily on the fact that he hadn't been found guilty of any ethical violations. He had some expert testify or, submit a written statement to that effect. But it is interesting because the judge even remarks in one of the cases that he invokes to justify his reason, the Georgia case, I think, that it's pending appeal. But the lower court said it was textbook frivolous litigation. If they even said that, I don't know. But it is.
Actually, they didn't because, to my knowledge, now there's requests for sanctions in some of the other cases outside of Georgia. But to my knowledge, he is yet to be sanctioned anywhere for a Rule 11 violation. That's a true frivolous filing. So if you have a good faith basis to challenge the law, you can bring so, even if a court determines it's legally meritless ultimately, because there's a big difference between bringing something that a court calls frivolous. Courts have called a lot of things frivolous, saying that you had human rights. If you were of a certain race or ethnicity or ancestry, a bunch of our American courts have called frivolous. So pardon me for deferring to court's definition of frivolous. But at a minimum, it's supposed to be a factual finding after a Rule 11 proceeding takes place. And he got less than a Rule 11 proceeding here. And it's just a big problem with courts acting as supervising. He's pretending he's not punishing Wood, and he's pretending he's not supervising other proceedings. But that's precisely what he's doing. Also, all this officer of the court nonsense, I've never agreed with that. Lawyers' job, they're officers of the Constitution. They're not officers of the court. They're not there for the court. I see that reference. We're not. Nobody swore me into the court. They gave me a license, and the only thing I swore to was to uphold the Constitution of the state and the United States I was sworn into. So this gibberish about officers, I don't work for the judges. Sorry.
I can push back only based on Quebec and Canadian law, where we are officers of the court, and the judges remind us we have a loyalty not only to our clients but to the honor and the integrity of the court.
The courts pretend that here, but that's just not constitutional. There's nothing. There's nothing in my oath that says I hereby swear an oath to affirm the integrity of the courts. There's no such thing. I uphold the Constitution. That's the only, and I believe that courts do that to compromise lawyers, and frankly, it hurts the integrity of the judiciary. I'll run into people who think, oh, no, you're an officer of the court. You can't really advocate for me. You have to protect the appearance of the court. And I make it clear, and plenty of judges have made it clear to me as well. But I don't share that opinion. That's not what find me the oath that I took that either made me an officer of the court or I swear a fealty to the court, because I don't know of one.
No, and it's an amazing thing because it's it could pressure some lawyers to say, well, I don't want to get in trouble with the court, so maybe I won't invoke that defense, or I won't, do this.
It happens all the time. I see lawyers throw their clients under the bus all the time. I was in front of this crazy federal judge in San Antonio. I ended up reading another book randomly about some other guy's famous case, and he's describing the same judge. I was like, oh yeah, that's the crazy judge. where I saw almost every lawyer in front of them so intimidated by them, they would throw their clients under the bus all the time. Your Honor, I think my client fled. They told me the other day. And I'm like, what the heck? I mean, it's a patent violation of attorney-client confidentiality, but it's one of those small courts out in the countryside where basically nobody can do anything about it. And if anybody does say anything about it, they get threatened, their career threatened, or their client's well-being put at risk. So it's a problem. And that's why I push back anytime. It's like I won't call somebody judge or Your Honor when they're no longer on the bench. I think that misleads people. I don't see it as a sign of respect. I see it as a sign of confusion, particularly in the arbitration mediation context. The ordinary person doesn't know the difference. They're like, okay, that's a judge like everybody else judge. You call them judge. That's why ethically they're not supposed to go by judge when they're no longer on the bench, when they're involved in mediation or arbitration matters. But these dishonest, greedy little people still do so. So that's my point of view.
All right, so that is that's the Lin Wood. So as of now, he's out of the Carter Page defamation suit. It might, like I said in my video, it's probably the best thing for Carter Page anyhow. But if the judge had it in for the lawyer, probably going to have it in for Carter. So
I mean, Wood's still pushing insane things. So I like the My Pillow guy, but he clearly has him convinced of things that are not going to happen. January 20th is going to come, and Joe Biden will become the new president of the United States.
All right. With that said, do you want to cover the forced vaccination discussion, the summary? Sure. So if anybody hasn't watched it, go watch the debate we had with Barnes, although some people said it was more a legal love fest than a debate, because by and large, like I said at the time, I think everyone agrees, most people can agree on the substance that, if, then, okay. And if all the ifs are satisfied, the then can be accepted, under normal certain circumstances. But so the summary that Dershowitz is putting forward, if the vaccine is safe, if it's effective, if it prevents transmission, if there's no risks associated with it or no meaningful risks. And what was the other one?
He basically agreed with my postulate. He got almost all the way there, is the way I think he put it. That it should be strict scrutiny, but that at a minimum it should be a substantial risk of severe harm is what's being protected against. The vaccine must be effective at preventing that substantial risk of severe harm and not itself inflict any substantial risk of severe harm. And on top of that, the decision maker should be first the individual, wherever possible. Secondly, if it's not the individual, then it should be done by the people's representatives in the most direct democratic form possible, such as state legislatures, and then adjudicated and enforced with constitutional rights protected, and that there can be exemptions for First Amendment grounds, certain speech grounds, certain religious grounds, certain belief grounds. Where we really disagree, in all likelihood, is on something that I was like, I get why Robert Kennedy went in certain places with him. I don't see Dershowitz as an expert in vaccines. I see him as an expert in the Constitution. So my view was, let's establish the constitutional parameters and see how much we can get him to our side of the position on that, away from rational basis review, away from deferring to white lab coats no matter what, away from letting the executive be the decision maker, requiring at least a heightened level of scrutiny. You notice he admitted very few vaccines will pass strict scrutiny. And that's why he was reluctant to adopt it. But that was not really a principled argument. That was a policy argument. And I was glad to see him reflect upon what happens when we apply intermediate scrutiny or any any level of scrutiny below strict scrutiny. And he did a wonderful indictment of the Buck case, to his credit. That was a beautiful indictment of the moral horror of the Buck case and the moral horror of the Korematsu case and the problems with enemy combatant cases. We didn't get as much into the third, but he mentioned his opposition there and to the government's unwillingness to be honest in the executive branch. We dealt with it in the police context, but it applies broadly as well. And he agreed that the white lab coats shouldn't be deferred to and that those in black robes shouldn't be the final arbiters. So all of that was fantastic to get him off of the position that he's been attributed as having. He claimed to you he hadn't changed his position. He was basically saying people mischaracterized his position, but
I didn't want to push back. When one can tell when someone is graciously tempering a decision that they might have said in a hyperbolic manner the first time. And I agree. So he's come back and said, yeah, under certain circumstances, but you agreed on a number of the issues.
Once you agree to all the conditions and limitations, and that there should be a trial presented, because that was one of the issues in Jacobson the Supreme Court skipped over. Jacobson wanted a trial on whether that particular smallpox vaccine was actually safe and effective. Supreme Court denied it by lying about how it was universally acknowledged that this had to be safe and effective when that wasn't the case. It was very good to see him say, one, that should be subject to hearings. Two, that should be there should be evidentiary tests to it. The adversarial process should be applied to it, both in the legislature and the courts. So once you establish those rules, then my view is, and I wasn't going to debate him on the substance of medical issues with COVID, because that's not an area where I think he's an expert. That's an area where Robert Kennedy is much more informed, and one of the most informed in the country, frankly. But right now, there is no COVID vaccine that fits any of those. That Dershowitz, the primary advocate right now for the idea of forced vaccines, says has to be done. So it was critical to see him acknowledge those limitations, because if you give me those limitations with any state legislature and court, and he agreed that both should apply, state legislature first, then the court have to agree with it, that it will pass. Because first of all, he acknowledged you couldn't do a forced vaccine for a flu. You couldn't do a forced vaccine for a regular virus. Well, the reality of COVID is, for people under the age of 60, it's not much different. I believe the evidence would show that the better evidence with a fair impartial jury, or fair impartial jurist, or fair impartial state legislature, or all three, and he seemed to agree with the idea of all three being applicable as tests to make sure before we get there, we should have these metrics of people in decisions of power and methods of evidentiary analysis and structure of legal framework. Once you agree to those things, my view is we win. The Kennedy argument, my argument, Robert Kennedy argument, is that COVID vaccine just can't meet it. Because one, there isn't a severe risk. There isn't a substantial risk. Two, there isn't a substantial risk of a severe harm to begin with. Three, this vaccine has not been proven to be safe and effective at all. The number four, there isn't proof the vaccine even protects against transmission, according to the World Health Organization, and now even the CDC seems to be implying that. So you don't have any of the tests. It has to be safe. It's not. It has to be effective. It hasn't been proven yet. There's evidence to the contrary. It's developed by Alex Berenson and others. So there's plenty of evidentiary presentation on that side. But just as importantly, maybe most importantly, right now, this vaccine, according to the World Health Organization, as far as I know from CDC, I think joined it recently, there's not substantial evidence that it significantly reduces risk of transmission. And that's why those evidentiary tests are critical. The critical component was getting Dershowitz to agree, here's the legal framework, here's the evidentiary methods, here's the decision makers, because once we have those three, I believe we win that no forced COVID vaccine can be constitutionally applied under the current evidentiary environment that we have.
All right, and Alex Daviduke says, Robert, please ask Trump to make an executive order to make vaccinations voluntary, make Biden force mandatory vaccinations. Bang. I presume you couldn't never make an executive order to that effect, because it would be an emergency situation in which you might have to make such.
I mean, he could say something, but this is not likely to come from the federal side. This is likely to come from the state government side.
Okay.
Because there's a big argument about whether it goes back to the individual mandate. Remember, they couldn't even require you to get health insurance. And the only way it got through was a 5-4 vote by pretending it was a tax. How do you pretend a forced vaccine is a tax? So it likely can't be federally imposed. Biden ultimately even admitted this about the masks, that he couldn't impose it aside from federal sources of employment, federal parks, et cetera. So this is going to stay a state issue. Okay. Now, Australia apparently is already broaching it, according to one of our local subscribers. So now different laws in Australia, but this will be one of the great constitutional fights of this year and maybe of our lifetimes.
I have family in Australia that I could probably get in touch with for some actually. Oh, and I know Avi Amini and the guys from Rebel, so we could probably get some good information on that. I want to bring this up because I want to show that I also bring up comments that I disagree with. Adam W., Nate Brody, Viva Fry, you trust that hyperbolic leftist hack. Not only do I trust him, Adam, I'm going to bring up his comment right now. Oh, why can't I better be able to find it. Where is it? Can I not find his... Nate, I may have lost your super chat. Anyway, I took a picture of it. So let me just go back to Nate, because Nate, without those judgmental terms, Nate is a reliable, intelligent person. Even if I think he gets caught up sometimes in the political side of things, he's a very smart person. And Nate, the lawyer, says to you, Robert, due process of a privilege, practice of law, is notice and opportunity to be heard, the Matthews test.
Potentially, but the difference is it's kind of a privilege and it kind of isn't once it's been vested as as appearance. So that's the difference. It's a privilege to appear initially. It's a property right once you've been granted the appearance, and the reason is because it's vested certain assumptions, economic and otherwise, in you and your client. And so almost every judge believes that they have the same. Like if this judge had said, "I recognize that there's a different standard to be applied once I've granted admission," then I would have more confidence that he was actually doing the constitutional test. I didn't see any evidence he actually said that. So and in my experience, in every case I've had, usually for other people, but sometimes for myself, judges are always shocked that once they've granted pro hoc vice, the same standards don't apply anymore. That it's no longer just purely a privilege that they can decide to do or not do. So and I've never been in agreement with that either. As a matter, the whole argument that it's a privilege is not something I agree with fundamentally. Pro hoc vice I get, but I think we should have national bar admission, not state by state. The rules for that, the reasons for that just they don't exist anymore in any real way. It's just a way for the local bar to practice monopoly and inflate people's pay, particularly of mediocre lawyers, frankly. And the second component is, I think anybody should be able to practice law. I don't think they should be able to occupationally control it through licensure in the first place. And I think once they do grant licenses, I think those should be seen as complete property rights, not mere privileges. And they play with that terminology so they can change the standard that they apply when they decide to screw you.
And it's an interesting distinction. Actually, it might not be justified in law, but that granting the pro hoc vice is a privilege. But once it's granted, and it's a good point, people make investments. If it can be revoked like that just because it's a privilege, the client who's invested $500,000, $3 million in their lawyer is going to say, "Well, now I have to get someone else up to the curve on the file." So I can see there being a distinction after the issuance as opposed to prior. And Derek Messina says, Nate is a great guy, not for a leftist or a righty. He's a great guy, very smart. I've debated him on Twitter, and it's always enlightening and civil. You should also subscribe to Nate Brody and Eric Hunley. The good guys. Snowden, Assange. I guess we only have a few minutes left, actually, because I hear the madness. Oh, sorry, go ahead.
I was going to say, I hope Trump pardons both. I know he's considering a bunch of pardons this weekend. He will be pardoning more people before he leaves. It's a big question whether Snowden or Assange are within that group. I hope they are, but it's not clear they will be. Apparently, Billy Walters was being considered, and I don't know how or why, but somebody leaked the fact that Walters had hired John Dowd, the former counsel for the president. Apparently, this is how much all these guys are grifters. They went around pitching that they had access to the president, and if you pay him 10 grand, 20 grand, whatever, probably more in case of Dowd, knowing his fees, he would lobby for your pardon, and that's just not good form. It's unfortunate. But my understanding is he is considering pardoning both Snowden and Assange. It's an open question. I mean, I can tell you Pompeo and all the defense establishment people don't want it to happen. So which is unfortunate. That's why I don't like either one of those guys. So I hope in terms of Pompeo and his allies. So I hope, and Grinnell, frankly, because Grinnell's been on that side in the past. Not clear he is right now, but that's where he was in the past. So I hope he pardons him, because the non-extradition of Assange doesn't mean a lot if the court overturns it, and he's constantly subject to the whim of he can still be kidnapped. He could be extradited from another country if he tries to leave or while he's in transit. So he's not at all safe. They're keeping him locked up when his mental health is deteriorating on a daily basis rapidly. It's ridiculous that he was ever charged in the first place. Another First Amendment violation. It was one of the embarrassing. The other reason the president should pardon him is it's frankly an embarrassment that the president's own Justice Department ever charged him in the first place. So it's something he needs to fix. He should now know with wide open eyes that the Justice Department was never on his side and was out against him all the way along. Look at how they're willing to be super aggressive at prosecuting everybody who dared walk in the Capitol without authority, while they spent the last 4 years undermining the president and covering up for their corrupt pals in high positions of power. So they're not people to trust at all. He should pardon Snowden and Assange because they're the greatest threats to the deep state that exist, and because what they did was heroic, not criminal.
Now, two people had asked the questions about Biden revoking liability for gun manufacturers. We'll do this on a separate stream, separate issue, but we'll get to them. Thank you for the chats. And now I brought this question up. Greg in Houston says, Steve Lito posted today about Superior Court, maybe it's Supreme Court, courts having non-lawyers as judges. all I want to say about this is that Steve Lito and I, after I thought and wrongly thought that I had been blocked from the comment section, reached out to me and said I hadn't been. And then we started texting back and forth or messaging. Turns out he's heavy into metal detecting, which I didn't know. And we're going to do a stream at some point in the near future. And I'm also going to do a stream with another YouTube lawyer, Ian Corzine, who's also a great guy. We did a stream on Eric Hunley's place just to share some love out there. This is good, Robert. I think we've done it, and we have 6 minutes left. Let's see. Is there anything? If anybody puts a question in there, we'll see if we didn't get to something that we can cram in the last 4 minutes. Anything?
I think there were some responses to locals, but I think we got to all the questions. I did an Ask Me Anything chat yesterday, and got over 1,000 questions. So I've responded to most of them on the vivabarneslaw.locals.com board. And any that I haven't got, I'll try to get to over the next week. I'm going to try to do that every Saturday. And then we'll look at maybe doing a midweek stream that's just a sort of freelance stream where maybe we have a topic that's of general use, like how to hire, what to look for in hiring a lawyer, advice for young lawyers or people approaching cases, things of that nature. And then just answer questions from a combination of local subscribers and chatters and super chatters. And so we may start doing that every Wednesday or so. This Wednesday has the inauguration, so that's going to be depressing enough watching that event. That's to that earlier question. My guess is there will be fewer people there than soldiers. Most of the soldiers don't know why they're there. They're being stuck, sleeping on the Capitol. There are more questions have arisen about what happened on the Capitol Hill, but to get into some of that more in-depth analysis, you can go to the Hush Hush episode on vivabarneslaw.locals.com.
We'll get, you know what, Robert, I've been thinking of doing an Ask Me Anything because I've never done one, but I don't know what types of questions people are going to ask that might be invasive. Like, how did my rubber band ligation surgery go?
I mean, I get questions like that, like, by the way, where do you live? How many people do you live with? I tend to skip those kind of questions, obviously. What I tend to do is I'll like the comment. If I don't know the answer to the question or don't think an answer would be productive, then I skip it. Try to answer as many as I can. But you get wide range. You'll get some questions about law, questions about life, questions about ideas, questions about strategy, questions about mindset. You'll probably get some different ones than I do. Why exactly you ice fish? Like, I thought you'd have a pole when you ice fish. I don't understand the hole in the string.
I mean, I need a shack, I need a tent, I need a lot of things, but I only get when I get out, I get out maybe for an hour. So if it takes too long to set up, I'd rather freeze my hands off and get an hour of fishing in. My kids don't want to go fishing with me now. Like, I've spoiled them. I want to play Scrabble. I want to go fishing. That's all I wanted from my parents growing up. I didn't get it. I give it to them. They don't appreciate it. Here, Joe Dufresne says, Paul, please ask Trump to make a statement. He won't pardon 6 January rioters. He's
not going to. He's not going to. I already know that. Trump is not happy with what happened at all. Trump had no interest in that, no desire for it. It was a sign to raise questions about who was being blamed for the event. That there was no logic for would Trump would benefit from this, or that he would think he would benefit from this, and he's very unhappy about the people that participate in illicit actions. So I see some people have been critical of him for not defending him. I'm sorry, people were dumb. That's on them. Alex Jones was down there screaming at people to get away from the Capitol. There was common sense to be applied, and more than a few didn't give it. Now, there's clearly some that were misled into thinking it was okay because they were invited in by Capitol Police and who weren't there initially and didn't know what was happening. But there are plenty of others who knew what they were doing was wrong, and Trump's not going to come to their defense. Why should he? They're acting like idiots.
And it's for anybody who thinks that this is not, like you say, it's not anything that Trump wanted. He knew, darn well the way it was going to be weaponized, exaggerated, blown out of proportion, or just harped on by media, politicians, and exactly how it's been done. So it was nothing in that speech that I heard rises to the level of insurrection. Oh, that was my question. Being impeached a second time has no impact on his ability to pardon, obviously.
No, okay. None whatsoever.
And now I'll end with Adam W. because I appreciate the back and forth. Viva, you think Nate is a great watch him with uncivil law on the Capitol breach. Then he's basically walking it back saying he was making a point. I know that Nate said some things the day of that he didn't walk back. He took back on Twitter, which is why I think Twitter sometimes brings out reflexive reactions in all of us. And I'm more inclined to forgive than to harshly judge. So, you know what? With that said, 1 minute left, Robert. Give us some words of optimism for the week, then we wrap it up.
Sure. So, I mean, I think for people to start taking more power into their own hands, the greatest trick the system pulled is convincing you of your own futility. So it may seem irrational to believe you have power, but the whole key for the system to do the worst things is to convince you don't have that power. Because if enough people recognize they do, then that's where power actually ultimately lands. So just start asserting that power in your ordinary everyday life in what ways you can, by independent means of technology, developing plan Bs, but also getting proactively involved and positively involved where it makes sense for you to do so. And there's a lot of places where that's going to be possible over the next several years and the next decade. So if you seize power, then that's the way righteousness can occur. Ultimately, Mandela was right. You are the captain of your own fate. You are the master of your own soul.
All right. And with that said, everybody, thank you all for tuning in. Robert, thank you as always. Stick around. We'll say our proper goodbyes. Locals, podcast, YouTube, we will be around. Everybody enjoy the rest of the weekend and have a good next week. And we will be